Welcome. I'm Marilyn O'Neill. I'm the Risk and Compliance Manager. Some people think I come in here to scare you every month. Others know that I'm here to empower you. I think knowledge is power, and that's what I want you to always work from, knowing something. Today what we're going to do is reference lease listings and leases in themselves. You do a lot of them. You really do. And my problem is I want to make sure that you know how to do them well. And it's important for you to do. The process of a lease goes much faster and is more compressed than a transaction for a purchase. Everybody understand that? Yes. Yeah. So you really have to have everything together when you're taking the lease listing and have it done perfectly, ready to rock and roll the minute you put it in MLS. And as a tenant agent, same thing. You'll show a property, and before you know it, somebody else has already grabbed it. So we're going to do a self-evaluation. And it is meant for you to understand that if you don't know the answers to these questions, you need to probably read the lease in particular. And if you're a lease listing agent and you like to do those, then you'll reference your listing agreement. Okay. The reason we're doing this is because TREC's rules changed a year ago for broker responsibilities. It put an unbelievable burden on the broker, but even more so on you. And the reason for that is because now TREC says that the broker must determine your proficiency on an ongoing basis. Years ago, when the broker said, oh, you can do that transaction, you know, they never came back and revisited with you on something. Now it's every transaction they have to determine if you're proficient or not. And so that's a huge thing. And the broker is not psychic, even though he's in this room right now. He's not psychic. And because of that, it's really meant for you. When do I not know enough to go forward? I need to stop, ask questions, get clarity. Because when you represent others, that is what you have to always stem from. You have a very high fiduciary duty to the party that you represent. So the first one says the only current TXR 2001 lease form has an effective date of, and what's the date? What year? That's a good thing. 9/1/2019. So if you're a listing agent or a tenant agent, you're only going to use the current lease. And the reason is the lease was changed because the Texas Property Code changed. And anytime the law changes, our leases always change. But Texas Realtors does more than just comply with what the Texas Property Code law is. They look at the evaluations that brokers and realtors from around the state recommend to them. You need to do this, or could you incorporate this? So they look at it at all times. So our leases, when they're changed by law, absolutely it's mandated. You cannot use one that is not approved by law. So just make sure. We've had a lot of problems with that. And once you have a lease that's already been signed by both parties, it's real hard as an agent, either the tenant agent or the lease listing agent, to go back to your parties and say, oh, we used the wrong form. That would be a real clear indication that the client could take your commission. Okay, because the reason we get paid is because we represent others in the course of the real estate transaction. Okay, so a couple of general questions. Number one, can you answer landlord's questions about eviction? No. Can you assist the landlord with eviction notices? No. Who does those type of things? Property managers or the landlord, that type of thing. And you know, here's where you get into a situation. You actually sold the property to this owner, right? And they're looking at you to teach them how to be a landlord. That is not your job as the lease listing agent. It's to procure a ready, willing, and able tenant. So what I am going to tell you is there is a great guidelines that I've given you over the years. Texas A&M Real Estate Center has it posted. It's the Landlord and Tenants Guide. It's in a Q&A format. It's real easy for people to read. Instead of you saying something, you are to be the source to the source. So just remember, they did update it, so it's up online that it's updated. Landlord does not allow pets and does not want any assistance animals. What should you do? Run. Yeah, exactly. Refer them to Century 21 agent or Coldwell Banker agent. There you go. Here's the problem. is fair housing was expanded to include assistance animals. As license holders, we are never going to tell a landlord, you don't have to accept it. We're going to always work on the premise that they're always going to accept them. Now, if a landlord has no problem with pets, they're absolutely not going to have a problem with assistance animal. The lease was purposely changed when fair housing expanded to stay in the problem for a tenant. Any damage caused even by an assistance animal, because they're not a pet, okay? They had to add that language so the tenant absolutely knew if I have an assistance animal and they cause any damage, that the tenant is responsible for that. So they did that a couple of years ago on that. But there are a few attorneys in this town that have a specialization to help landlords qualify prospective tenants and those types of things. So, you know, they may have to do that. A landlord would maybe have to hire them, or a property manager if they're not very comfortable in doing it. But our mantra is we will never, ever say anything to a landlord that they could decline a prospective tenant because they have assistance animals. Yes? Absolutely not. They're not a pet. They're an assistance animal. So they're in rights. You can't even say, well, I'm going to double the cleaning fee, or you cannot associate any fee with that assistance animal. To do so, you could be in front of the Civil Rights Division of the Texas Workforce at a hearing, and I've done that. I've played for you what the field investigator that was interviewed for fair housing, and they said that of all the cases that they've had regarding that, and Texas Realtors brought this specialist in from fair housing, because a lot of times people don't realize that a slight response, one of the agents that I helped the brokerage, they were a listing agent, called on a Monday by a nonprofit that was set up to trap listing agents. Okay, and they're still around in the state. They're still doing it. And the agent was asked by a prospective tenant, they said, oh, I see that you're listing this property for lease. And they said, yeah. Will your landlord allow assistance animals? And all that agent said was, I don't know, let me check with the landlord. He and his landlord, and you're not going to believe this, he had several listings by this same landlord for lease. And they called him on Wednesday too. So he had 2 violations. The landlord had to go and do it. They all spent over $10,000 individually. That's not covered under any errors and omissions insurance program at all. And so not only was the landlord charged, but also the listing agent. So be very careful about that. That's why I said, what should you do? You should run. This is not somebody you ever want to represent. Can I be on the lease to accept notices for the landlord? Never. When I say never, that means a double no. When does my fiduciary duty to the landlord end? Okay, when the lease commences, or maybe if your listing expires, it's done, okay? Once that lease commences, in the state of Texas, is your name anywhere on the lease? No, for a reason. Leases in Texas are between the landlord and tenant only. So when does my fiduciary duty to the tenant end? When the lease commences, or maybe when the buyer-tenant agreement expires, okay? And here's the reason I mention that is I cannot tell you, and I know Michael can vouch for that, how many times the tenant agent will get a call from the previous tenant saying the landlord didn't do this, or can I get out of my lease, all these questions. And while they think that you're going to be responding to them, absolutely not. You're going to let them know, no, this lease is between you and the landlord only. You must contact the landlord directly. That's how it has to be. Same way with the lease listing agent. Unless the seller or the landlord or owner could say you did something wrong, we're not going to be a part of that lease. That's between those parties, okay? And agents are, one of them said, well, I want this tenant one day to buy a house from me. Well, I understand that, but you cannot interfere legally. We've had agents get into trouble for that. It was an agent in this office about 6 years ago. her previous tenant called her and was so upset, and she wrote an email saying that you can do this and you can do that and all this type of stuff. And it was a very bad situation because it was in writing. So again, it's between landlord and tenant only. Number 7, can I represent an owner in listing one of their rooms in their home to a prospective tenant? No. No. I get that a lot, and a landlord really, when we list property, it's real property. It's not a room in real property, okay? So when we list it for lease, that's what we're doing. We're leasing the entire real property, not a portion of it. So just want clarity on that. Right there. Okay. What resource documents should you provide to a landlord or tenant? The guidelines, exactly. That's a really good thing to do it. If I were a lease listing agent, I would have it attached to my lease listing agreement and give it to them too as well. This is a reference for them to use. You can read it too. It's, as I said, it's a very easy document to read because it's in a Q&A format. But you are always going to be the source to the source, not the source. Chapter 91 and 92 of the Texas Property Code also affects landlords and tenants, so they can certainly read that if they want. Landlord lives out of town, state, country, and wants you to just deposit the rent for them. Is that okay? No, never. There you go. Please don't do that. I am the listing agent, and landlord needs help with accounting for the deposits for a previous tenant. Can I do that? No. These are all questions I get asked all the time. Sometimes we've had truck complaints and lawsuits, and we didn't even know this was all going on, but this is what the lease listing agent had done and those type of things. So it's good to have clarity on this. Now we're going to talk a little bit about the listing process. And tenant agents, listen up. It's important for you to know this too. How many of you like doing lease listings? Oh, well, I think I see one hand. Okay, you like them. There you go. So, can you process applications for the landlord? No. Your lease listing has no provision for that. You've got to stay into the lines of what you're allowed to do. Can you execute any documents on behalf of the landlord? No. What happens if the landlord tells you they are delinquent on mortgage, taxes, HOA fees? Yeah. Can you list the property? No. It would have to be front and center on the landlord rental criteria that the tenant would sign, that the landlord would put in big bold letters. I am not current on my mortgages. I'm behind on my taxes. That's what I'm trying to tell you. No landlord's going to do that, right? We've had several that when we found out they were in arrears, we did tell them that, and unfortunately the agent didn't find this out until later, because when they sent it to compliance, it was told that those paragraphs were blank, those provisions in 12 that says I'm current and all these things, and you never want a blank. Blank is, you know, we can't evaluate it, so you have to have NA, or that's when the question came up and the listing agent found out. Fortunately, they didn't have a tenant in it. They withdrew it temporarily until the landlord became current and had to prove in writing that they were current on the things that they were in arrears on. Does the landlord have to provide you a copy of the current lease if you're the lease listing agent? Yeah. Absolutely. It is in your lease listing. Don't be remiss and not have that in your possession. A lot of times, the reason for that, it's not like we're going to be able to sit in judgment on the previous lease, but many times we find out from the landlord, oh, they didn't have one in writing. Good luck on getting that tenant out. Or it's on a form that was not provided, you know, from Texas Realtors, meaning through another license holder. And many times, if they did use those types of forms, I had one agent, one-page lease agreement from the state of Connecticut. And the owner went out there and found it, and they liked it a lot because it was one page. but it didn't cover anything that the Texas Property Code requires. So it becomes very complicated for you, is what I'm trying to say, as a lease listing agent. You're not going to be able to get a tenant perspective until that gets cleared up. You may have a lease listing, but all of that will need to be cleared up entirely. Because there are many provisions in our lease that if they didn't have them in their current lease, the landlord might not even be able to list that property for sale and all these other things. So there's a reason for the lease form that we use. And you know, I'm just going to tell you right now, landlords need you. And a lot of you, you know, you think you have to process everything and tell the landlord everything they need to know. No, that's not the reason. The reason is not only are you able to procure a ready, willing, and able tenant through your marketing and other efforts, but you have access to copyrighted forms that they would have to pay $10,000 or more for an attorney to draft. Pardon me? Oh. So, don't ever think that you don't bring tremendous value to a lease listing. You exceed way more than whatever compensation you're going to get in paragraph 5. Make no mistake. Now, what if the landlord has no liability insurance on the property? Can you list it? Not unless you don't want to ever have anything in your possession ever for the rest of your life, because you will personally be liable if you're sued for anything. You can't have a listing for sale or lease and the homeowner not have liability insurance. You can't do that. And when you put it in MLS, who are you inviting? You're inviting everybody to bring their clients in to view it. Well, you don't want to be personally responsible for it, but the landlord, all they're going to do is throw their hands up and say, I told them, and you know, and the agent said it was fine. It is not fine. You're going to have to speak into a microphone, Mr. D, because of the viewers at home or wherever they are. You have 3 seconds. No.
1, 2. So where do you get a copy? Do you trust the landlord or the seller that they have liability insurance?
Oh, absolutely not. Now,
So you request a copy?
Well, what I would recommend, truthfully, is if you place that as a material fact in your listing agreement and special provisions, landlord has affirmed they have liability insurance on the property, if full and force during the course of the listing. I think if the landlord breaches that listing, they're going to be paying a whole lot more than whatever else they're going to be paying. They're going to indemnify you.
So if one has a long-lasting listing and the owner or the landlord cancels their insurance and doesn't notify you?
They would be breach of your listing agreement, especially if you added that language in there.
Okay, that's something new that I have not added before.
Yeah. Well, in fact, after my training last week, I knew how many agents listed properties that had no insurance, liability insurance by the landlord, because they all called me afterwards and said, I went back and I talked to the landlord. I can't believe they don't have liability insurance on their property. We had one landlord that had a portfolio of properties, and we're talking like 30 plus rental properties in the Houston area. Not one bit of insurance. Wouldn't that be hard to almost believe? And the agent told me, they said, I've listed for them for years and they have tons of properties and they just don't believe in insurance. So, you know, that's their choice, but we don't represent someone and have the ability to invite through MLS other brokers and their clients, as well as the clients here, interview that property without that.
I have a question. I understand liability insurance is important for the landlord, definitely, you know, especially when they're leasing multiple properties. It's an insurance for them, right? Just in case if something goes wrong with the tenant. Now, my issue is that why does the listing agent be responsible, or I mean, of course, for the landlord it's necessary, but is the listing agent in trouble in case if the landlord does not have a liability
Well, let me just explain the problems with this.
Sure.
If your landlord gets sued, you're going to be sued. And then the landlord's going to blame you. No, this is an agent who knows their business. They never mentioned that to me. And now this tenant, prospective tenant, came in and fell through the ceiling in the garage. All of what we say is true, unfortunately. No, after I did that, because I had to do it in San Antonio too, they changed the language on those BOP packages for owners because they didn't like the fact that we were able to find that loophole. And it just comes from reading their contracts. We're not lawyers, but I was a former insurance broker, and I understand how they pull everybody in for liability. But we've talked about this in years past. All of you as agents, to protect your interests, your personal interests, really need what they call a business owner's package or a general liability package for your business efforts and pursuits, because bodily injury and physical damage are never covered. And we'll be getting to some of those questions pretty soon. Okay, it has to be, there we go. I'm so sorry. Go on, Hilda, you're next.
So there is no language in the listing that asks the owner if they have liability insurance?
No, they talk about a vacancy clause in the listing agreement, but not specifically you verifying with the landlord and the landlord attesting by putting in their initials on the bottom of that page that they have enforceable liability insurance on this property and will maintain it throughout the course of the listing.
Could you please repeat the
No,
wording?
I won't be able to repeat that.
No, the wording that we should write in special provisions.
That's what I just did.
Okay.
Yeah. So you just have to make sure that the landlord has affirmed that they have liability insurance on this property, and it is going to be enforced throughout the term of the listing, something to that effect, very simply, between the parties. Yes.
Do you have to put that in during a regular listing? I mean, you'd think that the sellers have insurance.
Right. Well, I'll tell you, if you feel that there could be a situation where you're representing somebody who decided to sell their rental properties, or they don't live in
I
it.
don't do rentals. I'm just saying.
Yeah, there's nothing wrong with you affirming that. You would think if there's a mortgage, there's usually homeowner's insurance.
I'm going to run away.
No, you're not going to run away. Should I always attach the general information for landlords regarding assistant animals to the lease listing agreement? Yes. As I said, it's probably not important if your landlord has no issue and says that their policy is pets are fine, but when they say no pets, you better have that. Texas Realtors did a superb job. When this broadening of the language came down in the Fair Housing Act, they went out there and they created this form. And in that form, it clearly states the very narrow perspective a landlord could ask or inquire about the need for the assistance animal. God bless you. So again, it's a great document. You're not going to quote anything other than that. We did have a situation where a landlord received, it looked like a pre-printed form by a health professional out of state, where the prospective tenants were coming from. They were coming from Oklahoma. And when the landlord got it, it was like a pre-printed form. It did have all the language that the act requires be there and all the health professionals know, but it was no signature on it. It was just the person's name, but not their signature. And so the broker called me and he said, what should we do? I said, well, the landlord can call that health care provider and verify that this was their document. Okay, that's about all they could. And if they don't get a response, then that's going to be a problem for them, because they're relying upon the standardized form that had no signatory on it at all on something like that. But that's exactly what they did. And the landlord did call the contact details for the individual, the health care provider in Oklahoma, and they were not current, and they couldn't find them locally in the state agency for a license for it. So there are some things the landlord could do, and as I said, if you look at it from that perspective, they were trying to validate the documents they received. They weren't disparaging the need for the assistance animal with the applicant. They were really trying to verify the source of the document and making sure that it was correct. Well, it's out there on the websites. No, and Fair Housing has everything that would be there regarding assistance animals. So that might be the place that you would look at. Can I request compensation for renewals or if the tenant wants to purchase the property during the lease? Absolutely, that's part of 5D1 and D2. Don't leave those blank, okay? And what's interesting is this paragraph provision extends beyond the expiration of the listing. It continues on and is applicable as long as that tenant is in that property, okay? And the tenant either renews or they decide to purchase the property. So don't ever leave those blank as a lease listing agent, and make sure that they're completed. What if landlord wants to leave non-realty items in property during the lease? Can they do that? Yes, it's in the lease listing agreement. You have to identify it on something like that. Here's what I'm going to tell you as a listing agent. We had a situation and the landlord wanted to leave a baby grand piano in the property. They were going out of the country and they didn't want to store it because they felt that it would become, it probably wouldn't play the same when it came out of storage, having done that myself. So the deal is that that's pretty problematic for a prospective tenant to have anything that belongs to the landlord in the property. You know what I'm saying? We've had some landlords who said, I know this property has a 2-car garage, but I'm going to use the other half for my boxes. No, that's not usually what you want to go into on something like that. The one for the baby grand piano was over in Brays Heights area, and the landlord finally negotiated a substantial discount off their monthly rent to get the tenant to agree to it. And the tenant had their own attorney draft the addendum that they would not be responsible for anything. So it was real interesting because it went on for a long time, and the landlord was just determined to leave that baby grand piano in that rental property. And it took up quite a bit of room. It's not like you've got your whole living room to use. Now you only have, 3/4 of your living room or half of your living room. Does paragraph 20, lease requirements by landlord in the listing agreement, really need to be completed and every box marked? Yes. I would think so. As a lease listing agent, that's a real important paragraph of your listing agreement. So the landlord, if it doesn't apply, they're going to put NA or none. You know what I'm saying? Don't leave it blank. Make sure everything is completed. What is paragraph 20 really helping landlord provide to a prospective tenant? Their rental criteria. See, here's the deal. As a lease listing agent, I would never list a property for lease if the landlord did not provide the rental criteria. The rental criteria not only applies to the property, like no smoking on the property, no wall parties, no, all these different things, but it also has financial information that might be the criteria that the landlord is looking for. If you are a lease listing agent and your landlord does not provide that, you are at huge risk for being declared that you could be using discriminatory acts against a prospective tenant. It's the best way to help the landlord not move that marker for one tenant versus another. And as a listing agent, I would never take that risk. You don't want fair housing to apply to you in any way, shape, or form, assisting the landlord in changing their criteria. And every prospective tenant is always going to think, what? You didn't treat me fairly. You discriminated against me because of this. The key that we've always used is that the landlord can't have criteria for different applicants. It is general application, what their criteria is before application. Now, I am going to tell you, If the landlord got the application, had given the criteria, and the criteria was this credit report score or these types of things, right? And the tenant did not meet them. And the tenant says to the landlord, will you try and accommodate for accepting our application if we did these things? Would that be discriminatory if the landlord agreed to take 2 months security deposit instead of 1? No. No. And the landlord wouldn't be looked at as being discriminatory. A lot of times, tenant agents, some of them are really, really good, and they know when their tenant has an issue that might affect their acceptance on their applications. They usually go directly to the listing agent and say, could you run this to the landlord and ask them, would they consider these options? And those come from the prospective tenant. That's not the landlord changing their criteria by applicant. What do you tell the landlord in the listing agreement about any type of surveillance equipment in the property? Yes, there's a big disclosure notice. Just a friendly word of advice, you are always being surveilled. And your clients know that because it's in your buyer-tenant agreement. Just don't ever think that you're not. I cannot tell you the horrible situations the agents have been nabbed on, and the owners were listening to everything that was being said because they are surveilling that. So again, just make sure that they understand. They have to consult an attorney. That's what we tell them. There should be no surveillance equipment, and consult an attorney regarding this. The same thing we do in our listings for sale as well as our buyer-tenant agreements. But agents, you just need to be prepared. Somebody is always watching. They're not always supposed to be listening, are they? But anyway, they're always watching, you know. And we know for a fact that the landlord heard everything because they quoted exactly what the agent said to their clients on the back porch. They didn't even get off the back porch when the listing agent called them. That's how fast it was. And just because for you new agents, you can never bring somebody onto a property that has open containers of food or drink, right? You can never bring alcoholic beverages into a property. Everybody understand that? Should you as an agent be drinking with your clients and then showing properties? Nope. Well, I'm just checking. I just have to kind of say it just so I feel really good about that. Number 20, pardon me? I know, you just had to let it go out. Okay, does the landlord really need to provide written rental criteria to a prospective tenant before they make application? Yes. Yes, they really do. And as lease listing agents, that's what you'll have to do. As I said, it really helps prevent an appearance of discriminatory actions. Even though nobody will be discriminating, it has that appearance, so make sure that we don't do that. I'm going to bring up something that other offices have mentioned. We've had a situation where the listing agent wasn't on the property, but the tenants needed to view the property. The landlord, when they were asked about the showing, the landlord said, I will be there to open the property. Lease listing agents, that could be very detrimental for your situation. The reason is landlords don't know anything, and they open their mouth, they say things. And we had one that made disparaging remarks about the prospective tenant's assistance animals needs. And of course the listing agent, I had to tell the broker because I worked for both Keller Williams' office, but the listing agent wasn't in trouble nor the brokerage. It was the real landlord themselves out of their mouth. The tenant agent was at another Keller Williams office. They called me immediately because my concern is we never want to diminish if the party we represent feels that they have been discriminated. We're not going to say, oh no, don't be silly. You know, we don't do that. There are websites for them to go through and various things. And unfortunately, we've had a lot of issues with landlords. Having said that, some of them were leasing the property on their own. There wasn't a listing broker involved in those type of things. But caution your landlord about being anywhere around. It'll be much better because fair housing investigators testified that if the landlord puts their eyes on that tenant, and they have a substantial reason for this assistance animal and it is visibly apparent, the landlord can't say a word nor verify anything. Most of our situations, our landlords and the listing agent don't even know who the tenant is. They wouldn't recognize them if they saw them, right? So just be very careful, and as a listing agent, you want to make sure that the landlord knows not to be a part of the property. Now, some questions about the lease. Does everyone 18 years of age or older submit a residential lease application? Should the landlord use a third-party provider for processing applications, credit reports, and criminal background checks? Yes. The property managers, they have in their property management agreement, they're the only party that actually steps in the shoes of the owners. So they're acting as the owner. We are the representative of the owner. We don't act in their like the owner. We don't act as though we are the landlord. But property managers have a methodology. A lot of them use software to make sure the security of all the confidential information. Because on that application, that one document has all the private information that could, really critically impair if somebody hacked that information and got a hold of it. So we always we look at it from not only perspective of helping the landlord protect and secure information, but the lease listing agent as well as the tenant agent. You don't want confidential information in your possession. And the moment you've scanned it and sent it on to somebody by email, it's on your system, okay? And that's very dangerous for you. Hackers are getting so sophisticated today. And it runs in cycles. We have like every few months, everything will be quiet. And then all of a sudden we'll have a rash of hackers who've hacked people and taken the monies that they've sent to title or used an agent's email, quote, look like an email to divert funds for closings and those type of things. The biggest ones that we've had where the agent had to pay it was a listing agent who gave wiring instructions to a prospective tenant. They had a landlord that lived overseas. That is never done. Everybody understands that wiring information never goes through you or any way, shape, or form. Okay. Can a landlord leave non-realty items in a lease process?
If they lived overseas, how do you get it there?
How do you get what there?
Money to the landlord.
Well, the landlord would have to contact the tenant directly and do that. On the lease, the landlord says deposit in these accounts. That's what they usually do. They have direct deposit so that they know that the rents were paid in a timely fashion on something like that. So, can a landlord leave non-realty items in lease property? If they do, that's that paragraph 2 of the lease. So just make sure that everybody understands that. What would you consider non-realty item? A refrigerator, washer, dryer, anything that can be unplugged and not be permanently affixed to the property. That is non-real property. So God bless you. So make sure all of those things are always itemized in it. Pardon me? Furniture? You would have to have a non-realty item, and it would be itemized by room, every piece of furniture, and a picture would be taken, and everybody would know all of that. That's disastrous if you're a listing agent and it's furnished. It's just a lot more work than what you're going to be compensated for, because it's got to be very detailed by the landlord. You need can you pass back one of the microphones to, yeah.
If I represent the landlord and I get an application for that, the application should go directly if I use my Smart Move.
Yes, they should go into a portal to complete all that information.
Okay, but the application, an agent says, hey, I'm sending you an application.
They know the landlord will send a link so that your prospective tenant can come into the portal and complete all the information.
Okay.
Yeah, that's the best way.
Or the application can just be emailed to the landlord?
I guess it could be, but in those portals, they complete all the applications. There's quite a few individuals now that have software to do that. So they don't pass around paper anymore.
Right, that I
Yeah,
understand.
yeah, no forms.
Is a truck form loaded on My Smart Move?
There is no Trek form with
Well,
leases.
Okay.
Yeah,
the
no,
lease.
they have their own lease that they have, and it complies with the law.
Okay.
Yeah.
Okay, thank you.
When is the tenant required to occupy the property? Somebody, what? How many days? The tenant must occupy the property within 5 days of commencement. And here's how the tenant agent got into trouble on this. Their tenants were coming from out of state. They were so afraid they wouldn't get this property that they went ahead and leased it before they were ready to occupy it. Tenant agent knew that. And the landlord checks on their property and noticed that after the 5 days of commencement, the tenant still was nowhere to be found. So my hint to you as a tenant agent, if that is going to be the case, the parties can agree to something in special provisions regarding the allowance by the landlord for occupancy to be after that time frame, but don't let that go. Okay, yes, you need to get a microphone. Thank you.
All right. What happens if a landlord approves a tenant and then that tenant's significant other or new significant other decides to move in?
Are you talking after the lease is between?
After the lease has,
Yeah, well, no, the tenant can't have anybody on the property. In fact, mother-in-laws can only be there for so many days. There's a provision of how long visitors can be on the property. Nobody gets to be on that property past that as a guest unless the tenant and the landlord reach a written agreement on that. Yeah.
Okay.
And personally, if I were the landlord and found out, and the tenant said to me, you know, I just got married, I want to add my wife as an occupant or a tenant, the landlord's going to do their due diligence for that. Once that lease commences, we're not going to be involved in that. Okay. Uh-huh.
What if they have a baby? Seriously.
They have to notify the landlord in writing that there's another occupant. Landlord can't say nope, because that's against fair housing too. So yeah, they would have to provide all of that in writing to the landlord. Can a tenant terminate a lease if all the repairs are not done that the parties agreed to on the lease? If the tenant occupancy doesn't say, you can't say that the lease is not valid if there's make ready or if it's not clean or some repairs are not done. There's a very narrow scope of which a tenant could go to the landlord and say, oh, your previous tenant did move out. That would give them latitude to be able to terminate the lease. But on these types of things, as tenant agents and lease listing agents, when they agree to a condition, because when the tenant makes application, they ask the landlord to make these repairs. Okay? It would be best for you to make sure that if the landlord had agreed to that and they processed the application, it was approved, that in special provisions, it's very clear the timing on those repairs to be done. If a landlord agreed to have them all done before the lease commenced, that would be an element that the tenant may have more ability to say that the landlord has breached the lease. But we wouldn't say that because we're not attorneys. But I'm just saying, if it's real specific that the landlord agrees to all of these requested repairs to be done prior to commencement of the lease, I think that would bind the landlord making sure that they were done prior to the commencement of the lease. Can a tenant provide any notices or any requests verbally to a landlord? Never. That's only in writing. And we've had a lot of tenants, because the tenant agent is always called, they said, well, when the landlord came to provide the filter, I told him that won't work. It can never be verbal communication. It must be done per the lease, which is in writing, and they give you how to do that. Can a tenant pay rent in cash? Absolutely not. It's in the lease. So it says in the lease you can't pay cash. So I just want everybody to know these things. Landlords are required to make sure that it's in other funds, but no cash. Okay. And any tenant that would give a landlord cash is like giving them free money. Yeah. You know what I'm saying? Yes, I agree. I used to know a mortgage officer who lived in San Antonio. Do you remember Bill Morcher? He was. He had an office next to Craig's at one time. Well, Bill Morcher, he'd been a broker, a real estate broker, as well as a mortgage broker. Anyway, he had bought a lot of apartment and quadplexes in downtown San Antonio, and he used to tell me, he said, I'm packing today. And of course that was really scary for Bill anyway, to have a loaded weapon. But he did that, he said, because where he was going to collect the rents, and they were all in cash. You know, those type of things. His tenants didn't have accounts and stuff like that. But it was interesting because that was the first time I'd ever heard about collecting rents in cash on something like that.
Where is that?
In the lease. It's in the paragraph about your rent. Question 30. Can the landlord increase the rent during the primary term of the lease? No, they cannot. When does the security deposit need to be provided by tenant? No, it's before the landlord signs it. It's paragraph 10. And we have so many tenant agents who try and run interference and say, oh, we're not giving you the money. Well, then they've never read the lease either, because it's real clear that when the landlord signs it, they have the security deposit in their possession. If it's going to be different, the parties would have agreed to it in special provisions. Okay, if it's going to be any different situation. Does the tenant need to check utilities, including internet, prior to signing the lease?
Yes.
Yes. Does the tenant need to comply with HOA or condo rules?
Yes.
Well, here's what I'm going to tell you. I nailed a property manager because the property manager said, Marilyn, the landlord, the owner knows that they got a violation by the HOA. The mulch is not at 3 inches deep. I said, okay, well, did you attach the Property Owners Association rules and covenants and restrictions to the lease? They said, I have no idea what you're talking about. I said, well, let's just go look at what you had worked up as the lease. On the lease, in that addenda paragraph, it was not marked. They couldn't prove they ever delivered them. I don't know about you, but I don't know how a tenant could comply with them if they're not a part of the lease. So tenant agents, don't be remiss in something like that. In order for the landlord not to have issues regarding any violations that may come through condominium associations or property owners associations, you better make sure they're attached to the lease and that they were delivered. Okay? All right. What happens if tenant gets a new car or motorcycle? What does tenant need to do, and what is the time frame for notification in writing to the landlord? It's in the lease, and it's 5 days. And here's what happens. You know the neighbors? Well, they're really good friends with the landlord. They loved him when they lived there. And so if the tenants try and bring home a new motorcycle, a new vehicle, or a puppy, or a cat, the notification usually gets back to the landlord quicker than we can ever notify them, because the neighbor has alerted the landlords that they have brought a puppy onto the property, or a kitten, or a big old motorcycle, or a new vehicle. I had an agent ask, they said, well, what do you mean? When at the time they filled out the application, they gave 2 vehicles with their license plate numbers and all the type of things. I said, right. He said, but at the end, the landlord found out they had 10 cars parked there. Well, those are one of the situations where we all know the answer. The tenants are in breach of the lease, right? But we're not going to resolve that for the landlord. That's their battle to fight because of the tenant breaching the lease. But again, pass that on to anybody that you know, that you love, that's under a tenant agreement, lease. Can the landlord sell the property during the lease? Yes. Yes. Can the landlord enter property without notice? Absolutely. The Texas Property Code, that's the owner's property. That landlord owns that property. They have access. It's in paragraph 14 of the lease. That's how I know lease agents that represent tenants don't read this provision to your tenant, because I don't see enough modifications and special provisions that the landlord will provide 24-hour notice before access. Because there's not a tenant on earth that they understand that, the landlord could have access. They're thinking they're going to call first. They're going to get permission, and that's not the case. So pay attention to that. When I've taught the lease classes, I have highlighted in yellow the lease. These are our forms. They're through our association. And so I highlighted various paragraphs that have come back and really hurt the agents involved in the transactions. Give that highlighted copy to your tenant right away. Because if they read it and they have an issue, they should tell you, I want to try and negotiate this with the landlord before I make application, those type of things. Can a key box be placed on the property anytime if landlord is selling the property? No, the answer is yes, for sale. It has a clause that says within so many days, if the landlord plans to relet the property and lease it again, then it has a semicolon, the word and then says at any time that it's listed for sale. And make sure your tenants know this, that you work with, because that's another one of those that's kind of a gotcha thing. We've had many situations where the landlord, after the lease had commenced, and through no fault of their own, their financial situation changed, and they said, I've got to go out there and liquidate all my properties. So they had to sell the properties, and the tenants just exploded because they had just signed that lease, and they're thinking, now my enjoyment of the property is going to be interrupted because of all these showings and all those type of things. Usually we don't get in that debate, but I would recommend very strongly, if a landlord is in that situation, they're going to go directly to the tenant, and the tenant and the landlord will agree to something in writing that will be a part of the lease agreement, because that is a situation that happens from time to time. Yes?
Question, does a landlord have to tell a tenant if he's planning to sell the property, or like in an HOA, a condo situation with the new condo law, the whole, condo HOA can put the entire condo association on sale. So all units, say there are 100 condos in an HOA, and the board can put it on the market with the signatures of all the owners. So if it's currently on the market, it's usually a commercial real estate transaction, and it's listed with a commercial broker, but there's nothing there yet and nothing has been executed other than this listing. Does the landlord have to notify a tenant that this is going on before they sign the lease?
Well, I'm going to tell you, I believe in the golden rule. It is our preamble to the Code of Ethics. And what would be your answer? If you were a prospective tenant, would you want to know? Yes. That's enough to answer the question on that.
Well, let me ask you a follow-up question, but the lease transfers over to the new owner. So even if somebody buys a property, a condo?
Sure, we know that.
Yeah, so it won't affect really the tenant if they sign a 1-year lease?
Okay, I understand all of that. I asked a very simple question. Would you want to know that if you were a prospective tenant? And the answer is yes. And that's how we work with the Code of Ethics. So, and they don't take a Code of Ethics, but if you were an agent representing them and listing the property for lease, and you had that knowledge, you would impart that knowledge to the prospective tenant in writing. Okay, that's just what we do. We always want to treat every party fairly, even those that we don't represent. We have a fiduciary duty to treat them fairly. We have a very high duty to treat them fairly. Does a tenant inspect the property? Yes, they do. Paragraph 13. Because when they've signed that lease, they said, I've inspected the property. Okay? Inspecting it once they move in is not how it's done. Is tenant responsible for pest control? Yes. Interesting thing about pest control, if there are pests in the yard, will they finally find their way into the house? Yes. It's amazing. They will. So a lot of, you hear advertisements all the time for pest control companies about they do a general application in the yard as well, because it's not just about what can get into the property, but what's on the property that could wind their way in. So a tenant needs to be paying attention to that as well. Does the tenant need to maintain the yard? Yes, it's in the lease. Water the yard? Yes. And I mentioned that part about mulch because it has come up so many times. And again, if in fact the landlord has proven and provided and attached the documents to the lease, the tenant is responsible for maintaining at the standards that are set by all the restriction covenants for the HOA or condominium association. Is the landlord required to repair appliances? No, they can exclude them. It's part of paragraph 18, and it's an area where, say for instance, the landlord did leave some non-realty items. They left the refrigerator and a washer and dryer, right? Well, they're probably going to tell the tenant, hey, if one of those non-realty items goes out, I'm not fixing it. We've had more listing agents that have been hurt because they didn't represent the landlord's best interest, because that's what the landlord would want. And it's a clear type of provision between the tenant and the landlord. It's in paragraph 18. Should a landlord attach the owners association rules to the lease? Yes. As a lease listing agent, are you going to get those when you take the lease listing? You better. That's when you do it. 42? I don't like 42. Okay. If tenant dies during the lease, are they still subject to the lease? Yes. Even death doesn't get you out of a lease. So my caution to you is make sure you have your tenant really read that lease. Leases are very binding. We've had some that have caused problems for tenants that had a dispute with the prior landlord and they broke the lease and they were not able to get a mortgage, because a mortgage company is going to look at, have you ever defaulted on a lease or another mortgage, that type of thing. So leases are really binding.
Okay. If the tenant dies during the lease, are they still subject to the lease? If they're dead, how can they be subject to anything?
Their estate is.
What if they, okay, because I've had this situation.
Everybody who dies has an estate.
I've had a situation where my mom had rental property and the tenant died and she had nothing and she had nothing. So there was nothing.
Well, I'm not saying that landlords don't make difficult decisions. They have to all the time, just like sellers do. So, but the terms of the lease are very clear. It survives. It doesn't end when they're deceased. This is a contract. A contract is a contract. That's how they. Yep. Well, as I said, we don't cover that with them, but I wanted everybody to understand that. We've had a couple of situations like that. And now some things have been added to the lease, and on 9/1, that's one of the reasons for the change, is it was very clear what the landlord would be able to do with the decedent's belongings and notification, how that happens and stuff like that. So, well, they have to.
What is that?
In the lease, the tenant knows that in the event they die, there is a process that the landlord will go about contacting their heirs regarding the disposition of the belongings of the deceased tenant. So, next one is, okay, let's see. When does the landlord need to provide signed copies of the lease to the tenant? All lease listing agents should answer this. How many days? Okie doke. All right, it is 3 business days after the lease is signed. So as a tenant agent, you're going to make sure your tenant got a copy of it. At the bottom of our lease, there is a provision that the landlord must complete that says, I've done it, and this is how I did it. You know, either they emailed it or sent it overnight, return receipt requested, whatever. It's on the last page of the lease where all the signatures are. But it is 3 business days after the signing. What form is landlord required to provide if landlord declines tenant for credit score or credit report? Yes, there is a form for everything. What happened is when the Fair Credit Act was enforced, if a landlord does not provide all of this information in writing, they are violating federal law. So lease listing agents, you better help your landlord in complying with the law. It is TXR 2212, the adverse action notice. On that form, No landlord can ever give a credit report to a prospective tenant that was declined. You can't do that, but the federal law says, but you must provide the agency's information so that the tenant could contact them regarding this part that was on the credit report that the landlord declined. Now, the first paragraph of this form is really nice. It gives the landlord the ability to say, I've turned you down because you did not meet my rental criteria. Any listing agent that would tell a tenant prospect or a tenant agent the landlord didn't approve you is stupid. Either that landlord puts it in writing and you present the information from the landlord that it's signed on a document, or you could be in trouble. Do you know what I'm saying? One little slip of why you explained it, it'll hurt somebody's feelings, or you'll violate fair housing, all these different things. So we've got forms that allow them to put it in writing, so please use that. That's the best way to represent your landlord. It's on them. They're the ones who decided. And so they will have it in writing to you. Again, this adverse action notice, that very first paragraph applies to that area. The other paragraphs apply to the credit report or the credit score and the agency information that the tenant is required by law to receive. Okay, what if the landlord does not provide rental criteria to prospective tenant and then declines the application? Any fees that prospective tenant paid, that landlord's going to give them back. Okay, it's not fair. A lot of the agents use the Texas Realtors residential application form, and right above where the prospective tenant signs, it says that they've had access to it. So in the event the landlord chose not to do that, then you're going to absolutely reimburse them for any fees that they have paid for the application process. We had a horrible situation. It was going on in the Heights area. It's been 2009 maybe. It's been about 10 years ago. And one of the listing agents that had the agency was collecting fees and applications from dozens of prospective tenants on every property. And they all said it was non-refundable, all this different, kind of thing. Well, they got a TREC complaint. And it was proven that they were running a scam. They were depositing all the monies, all these different things. And about a year and a half ago, it reared its ugly head again. So make sure, as a tenant agent, if your tenant is in a multiple application process, the same thing applies to that notice prior to them going forward with the application. So as a tenant agent, make sure that you ask, are there any other applications on this property? You want your tenant to know all of that before they go forward with it. Then that would be their risk, because you're going to put everything in writing on that. Okay, it says if you are the listing agent and a prospect is interested in your listing, what forms do you provide them? Well, information about brokerage services you're required to provide to any prospect that you meet, right? The Texas Realtors created one about 2 years ago to help us comply with the law, and that's the representation disclosure. It would show that you represent the landlord only, and then the prospective tenant would sign and date that. They would never think that you represented them because it's in writing that you only represented the landlord. And then I would provide them the rental criteria immediately. Document that you've got it. Bring 2 copies, make them sign both of them, that kind of thing, if you meet them. Do not risk your life by meeting people that you have never met at your properties. Does anybody do that still? Yeah, I really worry about that. Just grab somebody. We had an agent at our office in San Antonio, Tony, and Tony was a big dude. He had his little girl with him, and he was showing a vacant property. Never met this prospect. The prospect called him, and Tony got there early, had the house all opened and everything, and his little girl was in one of the back bedrooms playing with her little dolls. It's a vacant property. And the guy walks in. He had to have been on mind-altering drugs, because he looked at Tony and he pulled a knife on him. Now, first off, nobody would do that to Tony anyway if they had sense. But the first thing that ran through Tony's mind was that his little girl was in the back bedroom. And it never dawned on him before. He'd never felt like anybody could threaten him because he's pretty threatening looking himself. You know, he doesn't look like he'll be taken advantage of. I know agents who've been in the business a long time that they've done this so long they think, oh, it's okay, no problem. It is a problem. I don't want you to ever meet somebody that you received a call from that you have not brought into the office and met them or had other people. Please don't take that risk. Grab somebody and say, hey, I'll treat you to, you know, Baskin and Robbins afterwards or whatever they like, Starbucks, whatever it is. You know what I'm saying? Just don't take that risk. There's no amount of business that's worth something like that at all. And please let your, you know, parties know that they should never open the door. If there is an idiotic agent out there that sees the sign in the yard and stops and runs up to the house and say, oh, I've got people who want to see the property, just tell your clients don't ever open the door to anybody who comes up and knocks on the door like that, just to be careful on that. And I'm going to end with some intermediary questions. Broker requires intermediary with appointments only. Your broker actually believes in your industry. They feel all parties need to be represented. I mean, if anybody thinks that differently, they can leave the room now because the industry, that's the only reason we're in this business. We believe everybody needs representation. When does the intermediary relationship notice, even on a lease, get executed with appointments? Prior to any application being done. That's really going to be the first document, okay, that you do provide. Does the listing agent need to verify that the buyer agent or tenant agent has a signed buyer-tenant agreement allowing intermediary prior to execution of the contract or application? Yes. I'm going to put it on the listing agent because you know who's in your office and who's not in your office. So do that. In the event that the other agent lies to you, well, they're not going to be with us much longer. We definitely don't lie to anyone in the transaction, much less to an associate of ours under the same brokerage as well.
Marilyn, if you need to have the buyers, if you're a listing agent, you need to have the buyer's agent present their buyer's rep agreement.
They don't have to present it to you, but you better put in writing, do you have a signed buyer-tenant agreement where the tenant or the buyer has allowed the broker to become an intermediary?
Okay.
Just something simple like that, and their response is what you will take. We don't ask for other people's document. I know Greenwood King does all the time, which is insane. I cannot believe what they still do that. It just drives me crazy. But from our perspective, who are they? I'll send you the list the next time I get the call on that one. Can you appoint yourself to both the owner and the prospect? If you do, I'm going to have to buzzsaw you in two. Because one part of you, no, it doesn't happen. But unfortunately, we have agents all the time that do that. And my thing is, if you've gotten the parties to already sign a document and now we realize you misused it, for you to go back to them has removed all doubt that you're negligent and incompetent. And that is not what I ever want you to be a part of on something like that. If you read the form, you knew that there had to be two people because it talks about it. If there is no intermediary and the listing agent is only representing the seller or the landlord, what is the tenant or the buyer? They're a customer. And customers may not always be right, but they always win. Big difference, right? And so it's very difficult. How many made 100 on this? Yay, wonderful. As I said, when you don't do leases often, you think they're, simple, goes real fast. It goes real fast. But there is a lot of information that is passed between the parties. And if you are not familiar with it, and you get questions posed by the tenants or the landlords, you've got to be prepared and know that you actually have read the document. You know what it is required. Do you have a question?
Marilyn, yes, I have a question. I have a situation right now where my tenant client is interested in leasing my lease listing. What do I do It's like
You have a
my
buyer
email.
tenant agreement with your tenant?
I do.
And you have a listing agreement with the seller? Okay, well, here's the situation. I had this discussion a little earlier with somebody else. What happens in something like that, that's called accidental intermediary. And here's what happens. Because you have such a high duty to the owner of the property, you will go to them first and explain. We have two options here. I have a prospective tenant that I have a signed buyer tenant agreement allowing the broker to become intermediary. You allowed the broker to become intermediary. Unfortunately, there's just one of me. So if I act like the broker with no appointments, and you have to have permission to do this from your landlord first, they have to understand in writing that you can give no opinions and advice, that you are an intermediary like the broker, you're just going to facilitate back and forth. Most owners don't release you because that's why they're paying you. So in that instance, the broker would appoint someone else just for this transaction to determine if they would go forward representing the tenant that you had a previous agreement with. Who owns all the buyer tenant agreements? Amen. The broker does. They own all the listing agreements. Their duty would be to step in and say, this is our agreement. I have it with you. I'm going to appoint another agent to represent your interest in this transaction. If the landlord or the seller says to you, you know, I'm fine. I don't need your opinions and advice. And I doubt they'll ever say that. But anyway, if they did say that, then at that point, you would go to your tenant that you have under a representation agreement and say, I've gone to the landlord first. The landlord says they have no problem with no appointments. I need to find out from you if you have any issue with me being a facilitator between the parties, but I couldn't give you any opinions and advice. And once you have their affirmation both in writing that they agreed to that after you told them all that, then the broker would agree to no appointments, but only under those circumstances.
Is there a form that I should use for request permission from both landlord?
You can do it from emails. You know, however you communicate with them, you can do it in an email, and then their response back to you based on that. That's difficult. First off, I am going to tell you, when there is only one agent in the transaction, it's real easy to point fingers at the one party that's done something wrong. We do believe in representation, but in this instance, there's a gentleman who's probably one of the premier real estate attorneys in the country, Chuck Jacobus. He wrote about this in his Principles of Real Estate, and it's called accidental intermediary, and it happens a lot of times more than what you think it does happen. What's interesting is every time we've had an agent from this office who's called, and I've walked them through this, they appoint an agent just for that transaction to see if they're going to get the property, right? Have they ever gotten the property? No. And Cindy knows that. Every time we have done that, there's something about it. It didn't work out. And then you just pick up where the other agent has left off on something like that. Where's that? There you go.
I had a situation like this with you.
I know, I remember that.
You said, it is my experience that neither one of them will get the property. And I thought, she knows me, but I'm going to get that property. And sure enough, neither one of them got it.
I know, I don't know how that works out, but all the agents who called me back, they said, oh, you know that thing that I had to appoint somebody temporarily to represent them? They didn't get the property, so I'm back representing them.
Can I ask you a question about MLS?
Sure.
Okay.
I don't know if I can answer, but you can ask.
If I am the listing agent and the seller is my niece and the buyer calls and doesn't have, they all have an agent. They're just not wanting to bother their agent for the most part. And I get my panties in a waddle. Am I allowed to say that?
Too late.
Okay. Can I tell them that per my MLS, per my agreement, that I am the procuring cause if I open the door, and that I don't have to pay the co-oping broker the same fee, the 3%.
Well, here's the thing. Procuring cause, a listing agent is, when somebody calls on that sign, it's the sign that was there, or they saw it in MLS, however it was brought to their attention in the internet. The listing broker is the procuring cause if that prospect came directly to them. The problem for an agent who will interject themselves into that situation after that prospect went directly to the listing agent is problematic. While you can say that, you know, if I open, I'm procuring cause, that's fine, but you can never, ever not compensate them based on MLS. You must arbitrate it after the transaction ends and pay over $400 and something to arbitrate it through Texas Realtors. That's how it works. Yeah, and so while you can make a notation in agent remarks about it that you're procuring cause, you must pay them based on MLS and then go after them later. That's what's happened.
But MLS doesn't allow you to put 2% if I have to open the door.
Oh, yeah, you can't do that. No, that's why I'm saying MLS is a unilateral offer. In the event that you have an issue with being the procuring cause and now interjects another broker to represent this prospect, at that point in time, you're going to go forward, you're going to pay them at closing, and then you have to arbitrate against them to get any money.
I don't think you've said that before, Marilyn.
Oh, I have, because I know procuring cause. I sit on the panel for Texas Realtors.
The piece here is that we can never interfere with the consummation of a transaction. That's why we have to wait till after it's over. And MLS basically dictates whatever we put in there.
Right. Well, and the thing is that I think Texas Realtors did this for a reason. About 15 or so years ago, each one of our boards had their own ombudsman and their own mediation type of thing, where everybody could come and the brokers could come and try and mediate the resolutions on things. But it was very costly for that endeavor, so they said, well, we'll send it back up to the association in Austin. Well, then they have very clear efforts about arbitration, and that's really what it comes down to. Our MLS is a unilateral offer. We can't modify that at any point in time unless the parties agree to prior to offer in writing between the brokers.
So we're going to be, so it's okay that if they have a sister or somebody else that is going to write the contract and we have to open the doors for all our listings?
Well, I didn't say it's all right. I'm just telling you the process that you would have to follow to arbitrate that matter after the closing and funding. And they've made it such that you have to pay money, so it kind of hurts you. And the effort, it doesn't go fast. It takes sometimes over a year for the arbitration to actually happen. But you don't get to diminish that unilateral offer in MLS in any way, shape, or form unless the brokers agree to it prior to an offer being presented.
Okay, and then one more thing. Can my niece open the door as the sellers?
I would never want a seller to be on the property and open the property.
Well, what if her husband's there with her?
Well, you know, you just take the risk that they'll say something. I think if they did open the property, they would have to vanish, be where they're not in the way of a party viewing the property. A prospect, when they're represented by another broker, they have the ability to view the property without somebody dogging them or being around them. And I don't know about you, but most prospective buyers would feel very awkward with the sellers in the property. I just know that for a fact, you know. So I think it's fine that they'd open the property, but they'd have to go somewhere where they wouldn't be interfering with that party viewing the property without the sellers kind of being around them. And they think our job is easy. Okay, just to close from some helpful hints that I talked about in some of these questions. You're not a property manager as a listing agent, and I know how landlords are. They're going to ask you all this. I just want you to be the source to the source. So besides sending them the copy of the Chapter 92 of the Texas Property Code, send them the link and then the PDF for the TAMU Real Estate Center Landlord and Tenant Guide. As I said, that's a real helpful guide both for tenants and landlords. Be very thorough on your listing agreement, and most of the work will be done because you want it to go fast and smooth, and the only way to do that is make sure everything is completed. And then pay special attention to paragraph 20. That's the landlord's requirements. Get the landlord to provide the tenant and rental criteria in writing and make it a part of the lease listing agreement. That's the best way for you because it shows you did all the right things when you took the listing. Get those association documents or condominium documents that you're going to have to attach as well. Now, once you have a prospective tenant, make sure that you read the lease to your client. Well, a lot of us are not going to sit there and read all those pages, but if you highlighted it like I had with yellow and said, well, the entire lease you need to read because before you sign it, please zone in on some of the areas I've brought to your attention. And if you have any questions about them, we may have to negotiate with a prospective landlord prior to application. So again, you need to do that and do that in writing. That's the best way to work with that. Now, if you are the tenant agent, and most good landlords have a template of a lease, right? They've signed off on it. It basically follows what their criteria is, paragraph 20, all this. If they send it over to you as the tenant agent and it doesn't have 9/1/2019 on the lease, what are you going to do? Here's what you're going to do. You're going to transfer everything they gave you on the old repealed form onto the current form. When you send that current form back to the other agent, you're going to just bring it to their attention saying, you know, the law changed on 9/1, and so my tenant agreed that they wanted everything on the current form. So that's how you do it without making enemies on something like that. You're not a property manager, so if the tenant asks you a question, don't answer it. Get the answer from the landlord. Ask the listing agent how the landlord would respond. You're going to ask the listing agent for the tenant selection rental criteria. Most of them don't know what you're talking about. The moment that happens, and it's been revealed to you now that the landlord's not going to provide anything like that, you're going to turn to your tenant and you're going to put it in writing and you're going to say, do you want to go forward with this or do you want to go on to another property? Put it back where it belongs, on the tenant in writing, and let them make that decision. Most tenants don't like that because they know how it's going to affect maybe them getting approved. The tenant might feel like they're not being fair to them and those type of things. The application and all fees need to be completed by the prospective tenant. You're the agent, you shouldn't complete them. The reason I had to do that is because we had an agent one time, a tenant agent. Their tenant didn't get the first property they really wanted. And the tenant agent had a little bit more time. The first thing was real rushed and all this. And the tenants filled out the application for that first rental potential by hand. And the tenant agent had more time than sense, and so they thought, oh, I'll just complete another one and have the tenants just sign it. And unfortunately, they transposed some information. And you can't lie on that application. That's the minute the prospective landlord finds out about it, that you've lied, or if they find out after you've signed a lease, it's immediate breach of the lease. So don't do that. And the reason I have to do that is because some agent thought that, well, it wasn't very clear. They had signed it and, you know, filled it out real fast and it didn't look very good. I don't care how it looks. Today we don't even want to share that kind of information except directly through a portal. Make sure that you provide the application of the representative of the landlord so the landlord can make a decision about the acceptance. We've had a lot of tenant agents who said, oh, well, we've looked at the criteria and it looks, you're going to get this property because it's perfect. You meet the criteria. That's not your decision. That's only the landlord. And the tenants got very upset because they didn't get the application accepted. And so as a tenant agent, don't ever do that. Just make sure they know it's the landlord's final decision. While you've met the criteria, it's obvious, but that doesn't mean that the landlord is going to approve you. We still have to go through that process. Don't maintain a copy of the application unless you've provided your privacy policy to your client. Our privacy policy complies with federal law that came out in 2009, and it says we don't have information, confidential information, anywhere hanging around. If we have any information, it is behind a secured portal. Okay, so that's our policy. And the reason I know that agents don't always abide by a privacy policy is because we've been called at 10-something at night when the cleaning crew found an agent's door was open and checks were out on the top of the desk and other things, and the cleaning crew said, hey, we've backed out, we're not cleaning this tonight, blah, blah, blah. So again, make sure you secure all the information that you might have of others, and if you're not not real good on maintaining privacy, you're going to find a way to make sure that you never have any of that information in your possession. Always abide by and comply with our privacy policy. If the tenants have any questions about any of the provisions in the lease or a response from the landlord, get it in writing from the listing agent. Don't assume anything. As I said, that landlord should provide that in writing to you, any of the responses. The other thing is, federal law says that any property built before 1978, there has to be a notice to a prospective buyer or a tenant. They're not the same form. We have a lot of lease listing agents that send over the one that we use for sales. Just remember that the one for leases is the TXR 2008. And use my helpful guide for tenant agents. I created that for a reason, because that process is very fast. And years ago, everybody thought, oh, well, leases are so simple. Do you know what I'm saying? This will be easy for you to get into the business and do this. They're not. They're very complex. They do have a compressed time frame, so you have to be better at what you do and have it all done well, because otherwise it could result in you not having covered all the bases, making sure that you're representing the parties well on something like that. So again, leases are one of those things that if you like doing them, there's a very wonderful experienced agent here who every time she does a lease listing, it's usually for a client that she's had for a long, long time. You know, they call and they're dear friends now, not just great clients. And every time she takes one on, she comes back and she says, I'm never going to do a lease listing again. And it's because if you don't do them often, you kind of forget. And it's a little problematic for you to remember all the various steps that you have to go to on something like that. Now, I just want all of you to know that I'm very thankful for so many things in my life, but more importantly, for you. And so for this Thanksgiving, know that I'll keep you in my special prayers for each and every one of you as you celebrate this wonderful time of year with your family and friends. I look forward to next year. They won't let me come back next month because they had a schedule problem. And in December, that's not uncommon. We've got so many things on the schedule and that. But what I'm going to do is I will send to Michael for distribution just a end of year kind of prelude to what you might be looking at for next year and some of the tips. TREC did meet last week. I am going to tell you in this letter that I'll be sending to all of you, the TREC Broker Lawyer Committee, everybody knows that that's a committee that is based on appointees, right? Then we have our TREC lawyers. And I don't know, did y'all hear where Governor Abbott was really upset because all these fees everybody's charging to acquire a license? Well, TREC got into trouble for that too. You know, there's oversight for TREC, so they've gotten into trouble this year too. But what it will be is that the TREC Broker Lawyer Committee is really the committee that we approach all the time and say, we'd really like you to revise this form to do this, or we'd really like you to add a new form or cover these areas. And they're really like our ambassadors to the TREC attorneys. They don't always agree with the TREC attorneys. Heck, the Broker Lawyer Committee doesn't even agree with each other. But there are individuals on that Broker Lawyer Committee. Ron Walker's there. He used to be the general counsel for Texas Realtors. He's been on a TREC's board many times and stuff like that. Wonderful attorneys, Bo Blackburn, a lot of good attorneys. And let me tell you what they're looking at. And it's great because they're taking our questions and posing our situations to them, and they're trying to come up with solutions. The biggest problem we have is receipt of option fee. And you're thinking, how could that be a problem? Oh, well, we do. Buyer's agents have the duty to make sure it's receipted within 3 days. Otherwise, the buyer doesn't have what? The unrestricted right to terminate. So here's what they're looking at. Because we've kind of posed to them, let's figure out a way that would be comparable to the commercial transaction. And for those of you who are not commercial agents, I'm just going to explain what happens. A commercial contract is signed by the buyer and the seller, right? Well, that's not really a contract until the buyer deposits the earnest money. I love it. It has that provision. Hey, we don't have a contract until you deposit the earnest money. That's why buyers under commercial contracts get that earnest money taken care of right away. And they're looking at it in the same vein for our residential. Case in point. Commercial transactions have a feasibility period. That's when the buyer is able to do their due diligence. It's comparable to our termination option. In the event something happens, within so many days they give proper notice to the seller, they're able to get their earnest money back. But they charge for a feasibility period because they have to charge for the unrestricted right to terminate these option fees. That's the requirement of law. You have to have consideration. So what they're going to propose is that in our residential contracts, the buyer will have to deposit the earnest money to have one. Then in the event that buyer terminates within the provisions in paragraph 23 with proper notice, the title company will then take the option fee and send it to the seller, and the remainder of the earnest money would go to the buyer who terminated. Oh, I am so excited. You cannot imagine how many thank you notes I sent. They do have task force that are going on right now and a lot of different things that we went through, like the leases. I told you about the proposed changes in paragraph 4 for the leases and all that. Well, they tabled all of those because they really feel there's more need to investigate it further. But this one about the option fee and how they want to handle it or think about handling it, I think is very positive. So comment to them, send them emails. They read everything we send to them, believe it or not. And that's the best way for us to kind of get our voice. The Trek Broker Lawyer Committee, you can comment to them. You can go onto the Trek website and be able to make comments to the Trek Broker Lawyer Committee. And all the attorneys are always, they have every meeting that the Trek Broker Lawyer Committee has, you can click on it and you see all the attorneys and all the brokers who attended it, who they are, and those type of things. But it's really important that we use them because, as I said, they really are presenting a side of it that looks more like they're helping being a liaison for us. Our association does a phenomenal job, and they always write and tell them what they think. But that Trek Broker Lawyer Committee really is where a lot of things begin, from our changes, our revisions, and our new forms. And so I'll be passing along some of those things that they're looking at for the future. But it's important that you stay engaged with them, finding out how to give your opinions and advice. And they do read it. They're required to read everything that's sent to them, even the stupid ones. Because I know we read
So
those.
Marilyn, when would that go into effect if they really did actually have that pass?
Well, they've got it in a workforce right now, so I'll tell you, there's some logistics issues that I'm having just alone. Can you imagine how much training the agents would have to be in? You know what I'm saying? That's a phenomenal change from our traditional way. So I would think that they probably, maybe next year might have more information on something like that. But the more we say, please focus on this, the more they'll put priorities on it. And that's really what we want to do because it's become a disaster for us. We have listing brokers and agents that are avert you so that you can't receive the option fee. You know what I'm saying? This is just insane in a business. So we need a resolution for this contractually so that the parties are in agreement on that. Well, good people, be very safe this week and don't eat too much and have a wonderful Thanksgiving.
I am very grateful for you, Marilyn, because when I have a question at 7 o'clock on Saturday night, I am respectful and text, can I call you? But I feel like I want to quit right now, but I feel like I'm very grateful for you. Even when you get mad at me.